Now for a question, Mr. Chair.
David, thank you for joining us. We have you for 10 minutes this morning before the committee, so I'll hand over to you to begin your presentation.
Thank you. My name is David John Harvey. I'm a retired District Court judge. I currently hold a practicing certificate as a barrister, and I have a Bachelor of Law degree, a Master of Jurisprudence degree, and a Doctor of Philosophy degree. I support the bill, and I believe it should proceed. It's a matter of such importance that I think it should be properly placed before the electorate by way of a referendum. I should say that although I'm a lawyer, I neither endorse nor support the submissions of the New Zealand Law Society and the New Zealand Bar Association. Turning to my submission, I focus upon Clause 6 of the bill, although it's critical to note that the bill does not in fact rewrite or amend the treaty itself. That is made clear in Clause 9. The committee, of course, will be aware of the principles that are contained in Clause 6. Principle 1 confirms the governmental structure of New Zealand in terms of what could be called a liberal democracy. Principle 2 secures property rights and by implication incorporates the concept of rangatiratanga, because that was a right that Māori enjoyed when the treaty was signed. Principle 3 provides for equality before the law and the equal enjoyment of fundamental human rights. The entablature of the United States Supreme Court building has the phrase equal justice before the law. That is what Principle 3 is all about. The courts, government and Waitangi Tribunal have developed a number of principles which it is argued will be excluded by the bill. I argue to the contrary. If we look at Principle 1, we have the power to govern New Zealand in the best interests of everyone. This incorporates the principle that the Crown has the right to govern. Edmund Burke considered that society is an enterprise that promotes the interests of all parties, and that partnership depends upon respecting those interests. The government, therefore, is a partnership between the people and the state, and thus the principle of partnership is necessarily preserved. As part of a partnership principle, there are a number of collateral elements. The active protection principle is inextricably linked to that of partnership. Given that Māori are a constituent part of everyone, the active protection principle ensures the protection of their interest. Implicit in any partnership is the principle of good faith dealing. If a government excludes good faith, it loses legitimacy and will fail. When there is a breakdown in a partnership relationship and wrongful acts are done by one partner to another, there is a right to recompense and adjustment, and thus that principle is present. The recompense principle is also recognised and given effect in Principle 2 of the bill. Thus, in my argument, the existing principles of partnership, active protection, equity and fair dealing, and remedies for wrongs are included in Principles 1 and 2 of the bill. I have approached the problem in the way that I have in an effort, I hope, to dial down the rhetoric and emphasise reason. And I am at your disposal if I can be of further assistance.
Thank you, Judge Harvey. We've got a couple of questions. First one from Willie Jackson, and then Rawiri Waititi.
Kia ora, Judge. Kia ora, Judge. Judge, you're out of sync with the best legal minds in this country. That you'll be aware of that. The King's Council, the creme de la creme of legal minds in this country, who have come out unanimously against this bill. You're out of sync with the creme de la creme of political leaders in this country, like Sir Geoffrey Palmer, Sir Doug Graham, Chris Finlayson. I just can't reconcile this, Judge, given your background and your status. Where does this put you in terms of the legal fraternity? Because the legal fraternity seems almost unanimously against this bill.
Firstly, Mr. Jackson, not all King's Council are of one mind on this particular point. Point 2, Mr. Finlayson made some interesting suggestions in his submission, as I recall. I wonder if he's looked at his watch lately, because in fact, we have daylight saving, which is the way in which time gets changed by parliamentary action. So the suggestion of parliamentary supremacy that he sort of disposes of so rapidly doesn't stand. It may well be that there are differences of opinion, Mr. Jackson. That's what living in a democracy is all about. I have approached this from the point of view of reason. Other people have approached it from the point of view of rhetoric and buzzwords. That's their privilege, of course. We live in a democracy. They have freedom of expression. It bothers me not one whit if I am out of sync with other people, or as you put it. I doubt that I am, but you're entitled to your opinion, as I am to mine.
Absolutely, Judge. Yeah,
Start from Willie and then we'll go to
yeah,
Ralph.
absolutely, Judge. I concur with that. Would you agree that this is an attack on the Māori tino rangatiratanga? That has been the constant criticism here. Do you agree with that?
No, I do not. And if you read my submission, you will find that.
Okay, thank you. Rowdy and then Todd and then Doug.
Morena, Judge. Thank you for your submission, firstly. And just to pick up on some of the stuff you talked about before I get to my question, especially around the equal rights for all in America. As we know, the civil rights movements didn't just come out of thin air and out of reason, to pull a rhetoric like that, where civil rights was only established in 1954 to 1968, I think does them an injustice. Māori are 30% of the people proceeded against by police, 45% of the people convicted, and 52% of the people in prison. And after that presentation, I understand why. Now, as a judge, do you respect the rule of law and 30 to 40 years of jurisprudence by the Supreme Court, by the Privy Council, by the High Court, by the Waitangi Tribunal, who have ruled in favour of Māori when it comes to treaty rights?
Do I respect the rule of law? Of course I do. But the point that you make is an interesting one, because if you read my submission and if you understand it, you will note that the principles that I have referred to are those that have been devised by the courts and by the Waitangi Tribunal. So there is no difficulty whatsoever in the incorporation of that jurisprudence into the submission that I have made. And I have said that those particular principles fold into this particular bill that is before the Select Committee at this time. So of course I accept the rule of law. It would be completely alien to my nature to feel otherwise.
If that's the case, then why would we have the need for this bill?
Because it's time that this sort of thing should be clarified. I think that there has been a lot of confusion about the way in which the principles of the treaty work. It is a matter which concerns every New Zealander and therefore should be put before every New Zealander.
Thank you.
And that is why I support it.
Thank you, Judge. We're going to go to Todd and then Duncan and then Tamaka.
Thank you, David. Thank you for your submission. And I've got to say, I think it was very interesting the way that you've been able to incorporate the current principles of the treaty as it's understood into this proposed bill. But my question, I think it follows on actually just from what you said. I mean, you see this as a totally legitimate discussion for Parliament to be able to have and then in the future to go to a referendum of the New Zealand people.
Yes, absolutely.
Todd, Duncan and then Tamaka.
Kia ora, Judge. Look, I'm just interested to draw on some of your experience in the District Court, where I have no doubt that you had a long line of defendants in front of you.
I sat in South Auckland, Dr. Webb.
Yeah, so in light of that, you would have seen the disproportionate representation of Māori in our criminal justice system, and I'm sure you would have seen cultural reports. How do you reconcile that with the suggestion that we should be narrowing down the scope of the treaty?
I'm not suggesting for one moment that we should be narrowing down the scope of the treaty. I refer you to Clause 9, which keeps the treaty in place. Furthermore, I refer you to the way in which I've developed my argument, which is that the principles that have been developed by the courts should be incorporated. The problem that we have, in my view, with the greatest of respect, Dr. Webb, is a political one. And it flows from the fact that successive parliaments both Labour and National, have failed to grasp the fact that the changes that are needed to get rid of this terrible disproportion, and it is a terrible disproportion of appearances in court, is not a 3-year problem. It's a multi-generational one. It's going to take 25 years to solve, and it requires a concerted effort on the part of everybody to
Thank
deal
you.
with it.
Thank you, Judge Harvey. So I'm sorry to interrupt, but that's the end of the